Thank you very much, David. We hear a lot of talk these days about human rights, and one of the most important human rights that we enjoy as citizens is the right to a fair trial. Criminal law in all civilized countries has operated on certain principles which have stood the test of time and have long been regarded as fundamental to the principle of natural justice. These principles include the presumption of innocence, the placing of the burden of proof on the prosecution, and what's known in legal speak as audi alteram partem. Both sides must be heard.
I'm just getting that up.
Okay. As far back as the 1760s, Robert Blackstone, in his commentaries on the laws of England, stated that it's better that 10 guilty persons escape than that one innocent person suffer. This message recognises that a jury in any case can make one of two serious errors. Namely, it could let the guilty person go free, or alternatively, it can convict the innocent. By far the greater wrong is done when the innocent person is convicted, and that applies to rape convictions more than any other convictions. Because when a man is convicted of rape, his punishment doesn't end when he's released from prison. That stigma attached to that conviction lasts for life. This principle that government and courts must err on the side of innocence has remained constant until recent times. To discard or dilute these principles would amount to a serious erosion of human rights, and yet that is now happening in this country in relation to cases involving rape, accusations of rape. This isn't something that's just happened recently. It's been happening incrementally for quite a few years now. However, I'm going to address just two current initiatives, both of which are designed to further erode the rights of the accused person in rape cases, and consequently increase the number of convictions, despite the fact that, contrary to public perception, the percentage of convictions in rape cases before the courts is already exceptionally high. Karen mentioned that she was on Radio Limerick yesterday, and during the course of that interview, the interviewer said something to the effect that the conviction rate in rape cases is very low. Back a bit. Sorry. Okay. Sorry about that. Back. Can you hear me now? Yeah. Good. Sorry about that. I'm not used to this, speaking into these gadgets. Anyway, as I was saying, Karen, during the course of this interview, the interviewer said to Karen that the conviction rate for rape is very low. And that seems to be a perception that's out there among the public. But if anybody took the trouble to check with the Office of the Director of Public Prosecutions, they'd find that the conviction rate is very high. The last year for which figures are available show that in rape cases before the courts, 82% resulted in convictions. I think the previous year it was 79%. So generally speaking, about 4 out of every 5 cases that go before the courts result in a conviction. The two initiatives that I'm going to talk about now are a review being carried out by the Department of Justice described as a review of the investigation and prosecution of sexual offences. And the other one is a review and knowledge and belief concerning consent in rape law, which was carried out by the Law Reform Commission at the request of the Attorney General. The review being conducted by the Department of Justice is still ongoing, and a report is expected in the new year. The terms of reference for the review include access to specialist training for Garda Síochána, members of the judiciary and legal professionals. The question arises here as to who's going to conduct this training. Will there be anybody who has any regard for the rights of the accused? Will they have any part in the training? Another term reference is practical support for victims through the reporting, investigation and trial process. You'll note here that the use of the term victim to describe a complainant. So they're effectively prejudging the trial by describing the complainant as a victim. An examination of measures to protect vulnerable witnesses, including the use of pre-recorded evidence or video link. Again, as I'll elaborate further on, this does erode the rights of the accused to a fair trial. They also want to look at the causes of delay in sexual offence trials and the effect of the delay on vulnerable witnesses. Vulnerable witness in this case is the complainant. But you notice there's no concern for the effect of delays on the innocent accused. The use of pre-trial hearings to determine evidential issues, including conflicts of evidence and sexual experience. Again, this prejudices the right of an accused to a fair trial, as I will also elaborate on. It's noteworthy that when announcing this review, Minister Flanagan directed that the review group shall in particular have regard to the recommendations of the publication of the Rape Crisis Network in Ireland, entitled Hearing Every Voice. The recommendations in the RCNI document are almost exactly the same as the terms of reference for this review. So effectively the review will probably just amount to a process to validate the demands of the RCNI. On a cursory reading, the RCNI document appears to give the impression of balance, particularly in recommendation number 2, where it states that special measures for vulnerable witnesses should also be available to vulnerable accused persons. Now this, on the face of it, appears to be fair, in that it appears to treat the accused and the accuser equally. But that's not the case when you delve deeper in. The inequality lies in the definitions. A vulnerable accused is defined as an accused person who is under 18, has a mental disorder, or has communication difficulties. So I think in that case that would only comprise a very small percentage of those who are accused. On the other hand, they want these special measures applied to victims of sexual violence, and their definition of victims of sexual violence includes all complainants. So therefore, all accusers or complainants will be covered by these special measures, but very few accused persons will be covered. This clearly puts an accused person and their defence team at a disadvantage. The demand that accusers, but not the accused, to be allowed to give pre-recorded evidence rather than be subject to cross-examination in court before a jury clearly puts the accused and his legal team at a disadvantage. One of the advantages of live evidence is that it gives the defence the opportunity to challenge the accuser's version of the defence in the presence of a jury, and the jury can observe the witness's tone, demeanour, and this can assist them in determining the witness's credibility. Subjecting an accused to cross-examination, not an accuser, would involve rigorously testing the accused, not the credibility of the accuser. This clearly tips the balance against the defence. The demand for pre-trial hearings is also designed to put the defence at a disadvantage. What they're looking for here is that prior to the trial, a judge would conduct a comprehensive review of the defence's questions and give directions for the conduct of the upcoming pre-recorded cross-examination of the complainant. This demand that the defence lay out its strategy for the judge to give directions on how it should proceed with its cross-examination denies the accused legal team the right to present their defence as they see fit. That is another erosion of the accused's right to a fair trial. Now, the other review I want to talk about, the other review I want to talk about is the ones carried out by the Law Reform Commission. This review has been completed and the report, as far as I know, has gone to the Attorney General who requested the review. Following the request from the Attorney General, the Law Reform sought submissions from the public, and they produced a discussion document or what they call an issues paper. This is it here. This document contained a number of proposed measures, all of which were designed to increase the number of convictions. The measures put forward for discussion were designed to impose all responsibility on the male party and absolve the female party for all responsibility for making any efforts to bring the intimate encounter to an end if she didn't wish it to proceed to what we could call its natural culmination. They were designed to inhibit the accused in presenting certain matters in his defence and prevent the jury from considering certain matters which would be of assistance to the defence. They contained absolutely nothing that would in any way enhance the protections for an innocent accused. In some instances, they reversed the burden of proof from the prosecution to the accused. In fact, they all appear to be based on the presumption that all accused are guilty. In other words, moving from a presumption of innocence to a presumption of guilt. When we found out about this and we got the discussion document of the issues paper here, we expected that it would be, given the rather draconian measures being considered, we thought that it would be a fairly balanced discussion, or we hoped it would be a balanced discussion document that would analyse the various measures in the context of whether they would serve the cause of natural justice, which is to acquit the innocent and convict the guilty. Instead, the pros and cons of the various measures are discussed on the basis of whether or not they will result in more convictions, regardless of innocence or guilt. The underlying assumption is that all accused are guilty, and measures must be taken to increase the number of convictions, even if that means eroding the rights of the accused. There's little doubt that these measures, if adopted, will result in the conviction of innocent men. If you search through this document to see what consideration they give to the possibility that these measures would lead to an injustice against an innocent accused, you'll search in vain. The possibility that such a vicious assault on the rights of the accused could lead to wrongful convictions has been totally excluded from this document. Did you get that up there?
I found it up on possible.
Pity. Sorry. I wanted to put up there's a certain paragraph in this document that gives you an insight into the mindset of the authors. I was hoping to get it up there, but we can't. Anyway, what it says is paragraph 10, and this is what paragraph 10 states. Still, it could be argued that it matters less whether the accused is convicted of intentional or negligent rape, but more so that the accused is convicted of something, and that the complainant is recognised as a victim of crime. And just since I can't put it up, I'll say it again. Still, it could be argued that it matters less whether the accused is convicted of intentional or negligent rape, but more so that the accused is convicted of something, and that the complainant is recognised as a victim. I think maybe you could say they let the mask slip a little bit there, but if you read the document, you'll see that it was a fairly transparent mask in the first place. That particular statement applied to a proposal to create a new lesser offence called gross negligence rape. In other words, a new form of rape that doesn't exist. In other words, they're going to classify something that's not regarded as rape now as rape, and they're going to call it gross negligence rape. The Law Reform Commission decided against recommending the creation of this new offence, but they didn't do so because of any injustice which may be inflicted on the accused. Their reasons for not recommending it were that the main disadvantage they saw with the addition of this new offence is that it may make prosecutions for the rape offence more difficult. They were concerned that if jurors could not agree, they could compromise by convicting the accused of the lesser offence, and that prosecutors may decide not to charge the accused with intentional rape, preferring the lesser offence, because they did not have sufficient proof of knowledge. You'd have to ask here why they would take a prosecution in the first case if they didn't have sufficient proof. However, that is just something that they didn't recommend. But their main recommendation, highlighted in their press release, relates to their dissatisfaction with the definition of rape in Section 2 of the Criminal Law, Rape Act 1987. The Attorney General requested the Law Reform Commission to examine and make recommendations on whether changes should be made to the element of knowledge or belief in the definition of rape in Section 2 of the Criminal Law, Rape Act, taking into account the jurisprudence and in particular the judgment of the Supreme Court in the DPP versus COR. In that judgment, the DPP versus COR, the court confirmed that an honest though unreasonable mistake that the woman was consenting is a defence to rape. But the Supreme Court also added that the accused's alleged belief must be genuinely held. The court stated that a jury is under no obligation to believe an obviously false story, and that jurors should use shrewdness and common sense to judge what the accused claims as to mistaken belief, and to do that, make that judgment against their view of what an ordinary or reasonable man would have realised in the circumstances. So what they've done there is recommended that we change from, at the moment, an honest belief can be grounds for acquittal, but they want a second test that must not only be honest, but also be reasonable against what an ordinary reasonable man would have considered. So the question is, who is the ordinary or reasonable man? In this case, I suppose it would be the jury themselves. But they didn't just leave it at that. They had a follow-on from that, which is an unbelievably restrictive recommendation, which would almost effectively prohibit a jury from considering the facts which would be most likely to show the belief was reasonable. In an appendix to the report, they included a draft bill to give effect to the recommendations. I won't get into this one because it's a complicated pity. In the appendix, they include a draft bill to give effect. It's by examining the draft bill that we can best see how this recommendation makes it almost impossible for a jury to conclude that an accused's belief was reasonable as well as honest. I'll read it out for you and hope you can follow it. Legislation isn't the easiest to follow at times. What it says is, if at a trial for a rape offence, the jury has to consider whether the man reasonably believed at the time of the alleged commission of the offence the woman was consenting, the jury shall have regard to A, the circumstances referred to in subsections 3, and only those circumstances, and B, the steps referred to in subsection 4. If I asked you what circumstances, we're talking here about a case where a jury accepts that there was a bit of confusion between the parties. They accept that the woman didn't give affirmative consent, and they also accept that the man honestly believed that she did consent. So I'm just wondering if I asked you what circumstances would lead a man to reasonably believe that she gave consent. I don't know if any of you got any ideas on that. Huh?
Contract.
Oh, is it a contract? Yeah, okay, contract. Well, yeah, in my experience, people rarely draw up written contracts in any rate, but there may be what you may call a verbal or implied contract. Essentially, if a jury is going to consider if the belief was reasonable, I think the factor the jury would take into account would mainly relate to the interaction between the parties in the lead up to the act. In other words, things like what they said to each other, particularly did she say anything to him that would lead him to believe that she was consenting. Her behaviour, could even be her, what I'd call her enthusiastic participation in all these stimulatory activities that lead up to these. I don't think I need to go into too much detail about what I mean there. But essentially, what would lead to it, what would lead the jury to believe it's reasonable would be that whole period leading up to the actual act. But what they say here is, as I've already said, what you shall have regard to are the circumstances referred to in subsection 3, and only those circumstances. Now the circumstances referred to in section 3 that they're permitted to regard are, well, the man lacked capacity due to a physical, mental or intellectual disability, had a mental illness, or was immature. Those are the only circumstances that they're allowed to consider. They're not allowed to take into account anything that happened in the interaction between the man and the woman in the period leading up to it. They also go on to say that they have to take account of the steps referred to in subsection 2b, which are the steps he took to ascertain whether the woman had consented. So effectively, under these recommendations, the jury is not allowed to consider any of those factors relating to communications between the parties in the lead up to the act. They can only consider the question of whether the man was incapacitated by physical, mental, intellectual disability, or mental illness, or immaturity, or if he took steps or can show that he took steps to ascertain her consent. If that, other than those circumstances, the jury has to find that the belief is not reasonable, and they have to find him guilty. It's my medication for polycythemia. Any words or actions or communications between the parties which would indicate that his belief in consent was reasonable, regardless of how compelling they might be, cannot be considered by the jury. These attacks, what I regard as attacks on human rights of the accused persons, are probably the most severe abuse of the rights of any group of citizens in this state since the foundation of the state. The only thing I can think of that comes near is internment without trial. Even back in the days when the security of this state was threatened, when innocent citizens were being killed in the streets by bombs and bullets, and some of that happened not too far from this building, such drastic measures were not even contemplated. But the people whose human rights and civil liberties will be affected by these proposals that I'm talking about, they're not terrorists. They're not the godfathers of the drugs trade. In fact, they're not really criminals at all. But they will be criminalized if these proposals become law. They're just ordinary young men. You'll see them out last night, tonight, socializing in cities, towns and villages in pretty much the same way that young men have always socialized. Unfortunately, some of them will find themselves accused of rape the following day, or maybe even weeks or months or years afterwards, for doing something even though these men never intended to rape anybody, or even may never have occurred to them that what they had just done was rape. They'll then find themselves in a criminal justice system where they will have less rights than a real criminal. Even the most recalcitrant career criminals enjoy rights such as the presumption of innocence undiluted. Their defence teams are allowed to present their defences as they see fit. The burden of proof for the real criminals is entirely on the prosecution. They will not have criminal interpretations applied retrospectively to their actions. They'll be entitled to cross-examine their accusers. And the juries in their cases will be entitled to consider all circumstances, especially those circumstances which may indicate the innocence of the accused. None of these protections will be available to the young man accused of rape. Earlier, I mentioned the Blackstone formulation, as is not, that it's better that 10 guilty persons escape than that one innocent person suffer. If this ongoing campaign, and it's not finished yet, if this ongoing campaign to erode the rights of the accused and rapist continues, the future our criminal justice system will operate on the basis that it's better that 10 innocent persons are convicted than that one guilty person escape. That is how perverted our criminal justice system is coming, because of the deference of the state institutions to the demands of certain vociferous lobby groups. Thank you, David.